Question 1. An investment advisor registered at the federal level with the SEC is required to make a notice filing with the administrator in a state if A. The investment advisor has a place of business in the state. B. The investment advisor has fewer than 6 clients in the state during any 12-month period. C. The investment advisor only advises institutional clients in the state. D. The investment advisor maintains books and records at its principal office in the state. Answer: A. The investment advisor has a place of business in the state. An investment advisor registered with the SEC, often referred to as a federal covered advisor, is generally required to make a notice filing with the state administrator if they have a place of business in that state, regardless of the number or type of clients. This notice filing helps the state keep track of federal covered advisors operating within its borders, even though the state cannot require them to register. This place of business rule is a key differentiator for federal covered advisors, as opposed to the de minimis exemption that applies to state-registered investment advisors. Question 2. Under the Uniform Securities Act, which of the following is an exempt security? A. A security issued by a private equity fund. B. A security issued by a Canadian province. C. A security issued by a savings and loan association organized as a for-profit entity. D. A security issued by a limited liability company, LLC, registered in multiple states. Answer: B. A security issued by a Canadian province. The Uniform Securities Act, USA, specifically exempts securities issued by the United States government, any state, any political subdivision of a state, or any agency or corporate instrumentality of one or more of these entities. This exemption is extended to securities issued by the Canadian government, any Canadian province, or any political subdivision of a Canadian province. Securities from private equity funds, for-profit savings and loan associations, or multi-state LLCs would generally not qualify for this specific governmental exemption. Question 3. A broker-dealer located in State A is conducting an active advertising campaign in State B, targeting potential new clients. The broker-dealer has no office in State B and all transactions are executed electronically. Under the Uniform Securities Act, must this broker-dealer register in State B? A. No, because all transactions are electronic and they have no physical presence in State B. B. No, unless they have more than 5 retail clients in State B. C. Yes, because conducting an active advertising campaign and soliciting clients in State B constitutes engaging in business in that state. D. Yes, but only if the administrator of State B issues a specific directive. Answer: C. Yes, because conducting an active advertising campaign and soliciting clients in State B constitutes engaging in business in that state. Under the Uniform Securities Act, a broker-dealer generally must register in any state where it transacts business. Actively advertising and soliciting clients in a state, even without a physical office or an agent making direct contact, is considered transacting business and therefore triggers registration requirements. The number of clients or the method of transaction, electronic versus in-person, does not negate the need for registration if a firm is actively soliciting in a state. Question 4. An investment advisor representative, IAR, is moving from one registered investment advisor, RIA, to another. Under the Uniform Securities Act, which of the following statements regarding the transfer of registration is most accurate? A. The IAR must notify the administrator, and the new RIA must also notify the administrator. B. The IAR must notify the administrator, and the old RIA must also notify the administrator. C. Only the new RIA must notify the administrator if the IAR is joining. D. Both the old RIA and the new RIA must promptly notify the administrator. Answer: D. Both the old RIA and the new RIA must promptly notify the administrator. When an investment advisor representative, IAR, terminates employment with one investment advisor, or broker-dealer, if dual registered, and begins employment with another, both the terminating firm and the new employing firm have a responsibility to promptly notify the administrator. This dual notification ensures the administrator is fully informed of the change in employment status, helping to maintain accurate registration records. Remember that the administrator needs to be kept in the loop by all parties involved when an IAR switches firms. Question 5. Under the Uniform Securities Act, which of the following statements is true regarding a security issued in connection with an employee stock purchase, savings, or pension plan? A. It is automatically exempt from registration. B. It is considered a federal covered security and requires only notice filing. C. It is exempt from registration if the administrator is notified 30 days in advance of the sale. D. It is exempt from registration if the plan meets certain conditions and the administrator is given appropriate notice. Answer: D. It is exempt from registration if the plan meets certain conditions and the administrator is given appropriate notice. The Uniform Securities Act, USA, provides an exemption from registration for securities issued in connection with an employee stock purchase, savings, pension, profit sharing, or similar benefit plan. However, this exemption is not automatic. It typically requires that the administrator be given prior notice, often 30 days, and that the plan itself meets specific conditions to ensure it is bona fide and not a scheme to evade registration requirements. Always remember that many exemptions under the USA are conditional, not absolute. Question 6. A registered investment advisor, RIA, is found to have commingled client funds with firm assets. Under the Uniform Securities Act, what action is the administrator least likely to take? A. Issue a cease and desist order. B. Require the RIA to post a surety bond. C. Suspend or revoke the RIA's registration. D. Order restitution to affected clients. Answer: B. Require the RIA to post a surety bond. Commingling client funds is a severe violation of fiduciary duty and is explicitly prohibited under the Uniform Securities Act. In response to such a grave breach, the administrator would be most likely to take strong enforcement actions like issuing a cease and desist order to stop the unlawful practice, suspending or revoking the firm's registration, and ordering restitution to make affected clients whole. While surety bonds are required for some registrants to ensure financial responsibility, ordering one as a remedy for commingling after it has occurred is less typical than directly penalizing the illegal act itself and rectifying client harm. Question 7. Under the Uniform Securities Act, which of the following is not a characteristic of a federal covered security? A. It is listed on the New York Stock Exchange. B. It is issued by an open-end management investment company registered under the Investment Company Act of 1940. C. It is a security sold to a qualified purchaser, as defined under federal law. D. It is a security offered exclusively within a single state by an issuer whose principal business is located in that state. Answer: D. It is a security offered exclusively within a single state by an issuer whose principal business is located in that state. A federal covered security is a category of security over which the federal government, SEC, has exclusive jurisdiction regarding registration, preempting state registration requirements. Securities listed on national exchanges, investment company shares, like mutual funds, and securities sold to qualified purchasers are all examples of federal covered securities. A security offered exclusively within a single state by an issuer whose principal business is located in that state would typically be an intrastate offering and would not be a federal covered security. Instead, it would be subject to state registration requirements unless a specific state exemption applies. Question 8. An investment advisor is providing advice solely to insurance companies. Under the Uniform Securities Act, what is the registration requirement for this investment advisor? A. The investment advisor must register with the state administrator. B. The investment advisor must register with the SEC. C. The investment advisor is exempt from registration as an investment advisor. D. The investment advisor must register with both the state administrator and the SEC. Answer: C. the investment advisor is exempt from registration as an investment advisor. The Uniform Securities Act provides specific exemptions from the definition of an investment advisor for certain persons. One such exemption applies to any person whose advice, analyses, or reports are related only to securities that are federal covered securities. More importantly, the USA also specifically exempts persons whose only clients are insurance companies, banks, or investment companies, provided they are not simultaneously acting as broker-dealers or otherwise falling within the definition. Therefore, an advisor dealing exclusively with insurance companies would be exempt from registration under the USA. Question 9. An agent's registration under the Uniform Securities Act is not effective until A. The administrator determines the agent is qualified and issues an order of effectiveness. B. The agent passes the appropriate examination. C. The agent's employing broker-dealer has registered and the administrator has granted the agent's application. D. The agent signs the application and it is filed with the administrator. Answer: C. The agent's employing broker-dealer has registered and the administrator has granted the agent's application. An agent's registration under the Uniform Securities Act is fundamentally tied to their association with a registered broker-dealer. An individual cannot be an agent without being employed by a registered broker-dealer. Therefore, for an agent's registration to become effective, two conditions must be met: the employing broker-dealer must be properly registered, and the administrator must have formally granted the agent's application. Passing an exam is a prerequisite to application, but not the final step for effectiveness. Question 10. Under the Uniform Securities Act, the administrator has the authority to deny, suspend, or revoke a registration if the applicant or registrant A. Has been convicted of any felony or misdemeanor within the last 10 years. B. Has been convicted of a felony involving securities or money within the last 10 years. C. Is insolvent, even if the insolvency does not involve any misconduct. D. Has failed to disclose material facts in an application, regardless of intent. Answer: B. Has been convicted of a felony involving securities or money within the last 10 years. The administrator's power to deny, suspend, or revoke a registration is broad but has specific triggers. A conviction for any felony or misdemeanor is generally not sufficient. It must be a felony or misdemeanor specifically involving securities, commodities, or money within the last 10 years. While insolvency can be a factor, it typically needs to be due to willful violations or demonstrate an inability to meet obligations, not merely financial hardship. Failing to disclose material facts with intent to deceive is a strong ground, but the regardless of intent makes option D incorrect. The administrator typically needs to find a willful material misstatement or omission. Question 11. An individual primarily sells life insurance but also occasionally sells variable annuities and receives commissions for these sales. Under the Uniform Securities Act, this individual A. Is solely considered an insurance agent and does not need to register under the USA. B. Is considered an agent of a broker-dealer and must register as such. C. Is considered an investment advisor representative, IAR, and must register. D. Must register as both an agent and an investment advisor representative. Answer: B. Is considered an agent of a broker-dealer and must register as such. Variable annuities are considered securities because their value fluctuates based on the performance of an underlying portfolio of securities. Therefore, an individual who sells variable annuities and receives commissions for these sales is considered to be effecting transactions in securities for the account of others, which is the definition of an agent under the Uniform Securities Act. Even if their primary business is insurance, selling a product that is a security requires registration as an agent. Question 12. Which of the following would not be considered a sale or offer to sell under the Uniform Securities Act? A. A gift of assessable stock. B. A stock dividend, where the shareholders can elect to receive cash or stock. C. The pledge or hypothecation of a security for a loan. D. An exchange of securities pursuant to a corporate reorganization. Answer: C. The pledge or hypothecation of a security for a loan. The Uniform Securities Act broadly defines sale and offer to sell to capture various methods of transferring securities or soliciting interest in them. However, it explicitly states certain actions are not included in these definitions. These exclusions include bona fide pledges or loans of securities, stock dividends if the shareholder cannot elect to receive cash, and gifts of non-assessable stock. A gift of assessable stock is considered a sale, and an exchange during a corporate reorganization is an offer/sale. Question 13. Under the Uniform Securities Act, an administrator may require an investment advisor to furnish which of the following to clients before or at the time of entering into an advisory contract? A. The firm's audited financial statements. B. A copy of the advisor's brochure, Form ADV Part 2A. C. A list of all current clients with their contact information. D. A bond equal to the total value of client assets under management. Answer: B. A copy of the advisor's brochure, Form ADV Part 2A. Both state and federal regulations require investment advisors to provide prospective and current clients with a disclosure document, commonly referred to as the brochure. This brochure contains important information about the advisor's business, services, fees, disciplinary history, and conflicts of interest. For state-registered advisors, this is typically equivalent to Form ADV Part 2A. This requirement ensures that clients receive essential information to make informed decisions about engaging the advisor's services. Question 14. An agent of a broker-dealer accidentally misrepresents a material fact about a security to a client. Under the Uniform Securities Act, what is the most likely outcome? A. The agent will face automatic criminal penalties. B. The agent and the broker-dealer may be held civilly liable, regardless of intent. C. Only the agent is liable for the misrepresentation, as it was an accident. D. The client has no recourse since the misrepresentation was accidental. Answer: B. The agent and the broker-dealer may be held civilly liable, regardless of intent. Under the Uniform Securities Act, the sale of a security by means of any untrue statement of a material fact, or any omission to state a material fact necessary to make the statements made not misleading, can lead to civil liability for the seller, the agent, and their employer, the broker-dealer. Importantly, the client does not have to prove intent or negligence on the part of the agent or firm to recover damages. If a material misrepresentation or omission occurred, liability can arise. Question 15. An investment advisor registered under the Uniform Securities Act is required to maintain client records for A. 3 years from the date of the last entry. B. 5 years from the date of the last entry. C. 6 years from the date of the last entry. D. Indefinitely, for certain critical documents. Answer: B. 5 years from the date of the last entry. Under the Uniform Securities Act, USA, investment advisors are generally required to maintain their books and records for a period of 5 years from the end of the fiscal year in which the last entry was made on the record. This aligns with federal regulations under the Investment Advisors Act of 1940 and ensures that records are available for inspection by the administrator. Keeping accurate and accessible records is crucial for regulatory oversight. Question 16. A municipal bond issued by the City of Houston, Texas, is being offered for sale. Under the Uniform Securities Act, this security is A. Exempt from federal registration but subject to state registration. B. Exempt from state registration but subject to federal registration. C. Exempt from both federal and state registration. D. Subject to both federal and state registration. Answer: C. Exempt from both federal and state registration. Securities issued by any state, municipality, or political subdivision of a state are exempt from registration under both the Securities Act of 1933, federal law, and the Uniform Securities Act, state law. This broad exemption applies to municipal bonds, which are generally considered very safe and are issued by governmental entities for public purposes. Therefore, a municipal bond issued by the City of Houston is exempt from registration at both the federal and state levels. Question 17. Which of the following is not a reason for the administrator to conduct an inspection of a broker-dealer's records? A. To determine compliance with capital requirements. B. To verify the accuracy of customer account statements. C. To provide investment advice to the broker-dealer's clients. D. To investigate a customer complaint regarding a transaction. Answer: C. To provide investment advice to the broker-dealer's clients. The administrator's role is to regulate and enforce the Uniform Securities Act, ensuring compliance by registrants. This includes conducting examinations and inspections to verify financial solvency, review records for accuracy, and investigate potential violations or complaints. However, the administrator's function is strictly regulatory. They are explicitly prohibited from providing investment advice to clients or acting in any capacity that would conflict with their oversight responsibilities. Question 18. An individual who represents an issuer in effecting transactions in their own securities is generally exempt from agent registration if the transactions are: A. Made with the general public. B. Affected by an agent already registered with a broker-dealer. C. Exempt transactions, such as those with existing employees or in certain qualified retirement plans. D. Transactions in federal covered securities. Answer: C. Exempt transactions, such as those with existing employees or in certain qualified retirement plans. While generally anyone who affects or attempts to affect transactions in securities is an agent and must register, the Uniform Securities Act provides specific exemptions for individuals representing an issuer. These exemptions typically apply when the transactions are themselves exempt transactions, such as those involving an issuer's own securities with its existing employees, directors, officers, or partners, provided no commission or other remuneration is paid directly or indirectly for soliciting any prospective buyer. Selling to the general public or federal covered securities typically requires registration. Question 19. Under the Uniform Securities Act, if a registered investment advisor moves its principal office from State A to State B, what notification is required? A. Only State B must be notified, as it is the new principal state. B. Only State A must be notified, as it is the former principal state. C. Both State A and State B must be notified promptly. D. Neither state needs to be notified if the investment advisor is a federal covered advisor. Answer: C. Both State A and State B must be notified promptly. When a registered investment advisor changes its principal place of business, both the administrator of the state from which the advisor is moving and the administrator of the state to which the advisor is moving must be promptly notified. This ensures that the regulatory authorities in both jurisdictions have accurate and up-to-date information regarding the advisor's primary location of business, which is critical for jurisdiction and oversight. Remember, effective communication with the administrator is key for compliance. Question 20. An investment advisor registered in State X has no place of business in State Y but has 4 retail clients who are residents of State Y. Under the Uniform Securities Act, what is the registration requirement for the investment advisor in State Y? A. The investment advisor must register in State Y. B. The investment advisor must make a notice filing in State Y. C. The investment advisor is exempt from registration in State Y due to the de minimis exemption. D. The investment advisor must register only if it solicits new clients in State Y. Answer: C. The investment advisor is exempt from registration in State Y due to the de minimis exemption. The Uniform Securities Act provides a de minimis exemption from registration for an investment advisor that does not have a place of business in a state and does not direct communications to more than 5 clients who are residents of that state during any 12 consecutive month period. Since this advisor has only 4 retail clients in state Y and no place of business, they fall within this exemption and are not required to register in state Y. Question 21. Which of the following statements regarding the administrator's power to require the filing of sales literature is true? A. The administrator may require the filing of sales literature for any security, including exempt securities. B. The administrator may only require the filing of sales literature for non-exempt securities. C. The administrator has no power to require the filing of sales literature if the security is federal covered. D. The administrator may require the filing of sales literature for any non-exempt security, but not for exempt securities or federal covered securities. Answer: D. The administrator may require the filing of sales literature for any non-exempt security, but not for exempt securities or federal covered securities. The administrator has the power to require the filing of sales literature and advertising for securities that are subject to registration in the state. However, the Uniform Securities Act generally preempts state administrators from requiring the filing of sales and advertising literature for securities that are federal covered securities, or for those that are exempt securities, under the USA itself. This distinction is crucial for understanding the limits of state regulatory authority. Question 22. Which of the following persons would not be considered an investment advisor representative, IR, under the Uniform Securities Act? A. An individual who gives investment advice to clients for a fee. B. An individual who supervises employees who give investment advice. C. An individual who solely performs clerical or ministerial duties for an investment advisor. D. An individual who determines which recommendations are to be given to clients. Answer: C. An individual who solely performs clerical or ministerial duties for an investment advisor. An investment advisor representative, IAR, is generally an individual who represents an investment advisor in performing functions such as giving investment advice, managing client accounts, soliciting clients, or supervising employees who perform these functions. An individual whose duties are purely clerical or ministerial, meaning they do not involve giving advice, managing accounts, or soliciting, is specifically excluded from the definition of an IAR. Question 23. A cease and desist order issued by the administrator against a person for a violation of the Uniform Securities Act. A. Requires the person to take affirmative action to comply with the Act. B. Is a final judgment and cannot be appealed. C. Is issued without a hearing and has no immediate legal effect. D. Is limited to preventing future violations and cannot compel corrective action. Answer: A. Requires the person to take affirmative action to comply with the Act. A cease and desist order is a powerful tool used by the administrator to stop a person from engaging in specific unlawful activities. It can compel the person to cease the prohibited action and, importantly, may also require them to take affirmative action to comply with the Uniform Securities Act or any rule or order thereunder. While such orders can be appealed, they are issued with immediate legal effect and can compel corrective action. Question 24. Under the Uniform Securities Act, if a federal covered advisor terminates employment with an investment advisor, who is responsible for notifying the administrator? A. The federal covered advisor is solely responsible. B. The investment advisor is solely responsible. C. Both the federal covered advisor and the investment advisor are jointly responsible. D. Neither is responsible for notifying the administrator. Notification is only required for state-registered IARs. Answer: A. The federal covered advisor is solely responsible. The responsibility for notifying the administrator when an investment advisor representative, IAR, terminates employment depends on whether the IAR works for a state-registered investment advisor or a federal covered advisor. If the IAR works for a state-registered investment advisor, both the IAR and the investment advisor are required to notify the administrator. However, if the IAR works for a federal covered advisor, only the IAR is responsible for notifying the administrator. This difference is a frequently tested distinction. Question 25. Under the Uniform Securities Act, a state-registered investment advisor is prohibited from A. Charging performance-based fees to clients. B. Exercising discretion in a client account without written authorization from the client. C. Holding client funds or securities. D. Engaging in principal transactions with clients, even with disclosure. Answer: B. Exercising discretion in a client account without written authorization from the client. Investment advisors are held to a fiduciary standard and must obtain written authorization from a client before exercising discretionary authority in their account. This is a fundamental requirement designed to protect clients and prevent unauthorized trading. While state laws may place restrictions on performance-based fees, often limiting them to qualified clients, holding client funds, custody, or engaging in principal transactions, requiring specific disclosures and client consent, the requirement for written discretionary authority is a universally prohibited practice without that written consent.